Yes, Milord, I am filing synopsis, Milord.
Yes. There is the opposite counsel. The first round somebody was there.
Yes, Milord, is there, Milord.
Where is he?
There is a simple issue, Milord.
Anybody representing who is the opposite party? High Court.
Yes, Milord, Raj Kiran, Milord, his colleague is
Somebody
there.
was there in the
Yes,
first
Milord.
round.
Simple issue, Milord.
If he is there, we are
Yes.
ready to hear you. You just narrate the facts in the meantime.
Yes, Milord. Milord, the petitioner, Milord, is Milord retired as junior assistant, Milord. Was kept under suspension, Milord, by proceedings dated 13/11/2006, Milord.
You were suspended for what reason?
But on the ground that Milord is involved in a criminal case, Milord.
Yes, you continue.
On the ground that Milord is involved in a criminal case.
Yes.
Milord, subsequently, Milord, for the same set of allegations, Milord, disciplinary proceedings were initiated. Milord, subsequently, Milord, after concluding the disciplinary proceedings were dropped against the petitioner, Milord. And subsequently, Milord, he is reinstated into service, Milord, on 27/9/2011, Milord. After his reinstatement, Milord, he made a representation to regularize the suspension period, Milord, as was done in case of other similarly situated persons, Milord, wherein they, against them, Milord, charges were they were imposed with the punishment of deferment of 2 increments. In spite of the same, Milord, suspension period was regularized on duty.
They are co-accused with you.
Same issue, Milord.
They are co-accused in the same case,
Same case, Milord.
criminal case.
Criminal case as well as disciplinary proceedings, Milord.
And they were punished in the departmental
Yes,
report.
Milord.
How their suspension period was treated?
On duty, Milord. They are treated as on duty.
You have pleaded about that, that
Yes, Milord. In
they have
fact,
pleaded and filed those documents?
yes, Milord. In fact, Milord, I filed a better affidavit, Milord, on the instruction, on the directions of this honorable court, Milord. Stay.
Where is the assertion that
Yes,
they
Your
were
Lordship.
co-accused and they,
Yes, Milord.
you were not punished, they were punished, yet their period are treated as spent on duty?
Yes, Milord.
Where is that assertion in your petition?
Milord, para 6 of Milord, my affidavit, Milord, I filed, Milord.
Yes.
I submit that agreed by the above said address, I filed a petition stating that though the authorities regularize the suspension period of the individual, namely D. Rangaswamy, T. Prabhakar Reddy, also involved in the same issue, and though they were suffered with imposing of punishment of deferment of 2 annual grade increments with cumulative effect, the suspension period was regularized as on duty. Though the charges against me were dropped, my claim was rejected only on the ground that criminal case is pending. I submit that the individual kept under suspension while order dated 29/9/2006 in view of involvement in the above criminal case. The above individuals were reinstated into service while orders dated 7/9/2011 treating the suspension period as on duty while imposing the punishment of deferment of 2 annual grade increments with cumulative effect. That last occasion, Milord, your lordship directed me, Milord, to
Where is the government? They filed any response to this better affidavit?
no, Milord, they are not filed.
When did you file this better affidavit? Recently, 8/11.
8/11.
And this foundation is not there in your writ petition?
In the writ petition, Milord, I'm stating that, Milord, though he was suffered with punishment in the same criminal disciplinary proceedings, Milord, in so far as criminal cases, Milord, I am not exactly pleaded, Milord. That
Let
is why,
them
Milord.
file counter, because ultimately this is purely a new ground of parity which you are raising by way of better particulars, better affidavit. Let them file a counter to this.
Yes, Milord, you also
It
can
is such and such for the petitioner place reliance on certain averments of better affidavit and submits that these averments were not there in the original petition. So thus, respondents did not get any opportunity to rebut the averments of this better affidavit. Thus, in the interest of justice, respondents are directed to file counter to this better affidavit within 3 weeks list thereafter. To kindly inform the council for the other side.
Obliged.
keep this with that.
Last week, can you delete from caption of dismissal?
And the dismissal had be removed.
Obliged.
Somebody made request. None for the petition in the passover round list of, somebody appeared in the first round. List in the list after a week under same head. Yesterday's matter.
Yes, yes. Lord, before the learned council commences, Lord, item 71, my lord, there is no challenge to 29. In fact, my lord, it is a EWS matter. Challenge is to the quantum of fixation of EWS. It should be 6% according to the petitioner, in which pleadings are not complete, my lord, that has to be detyped, my lord. Item
Who
71.
is appearing for the petition?
My friend appears.
I'm appearing for the petition. Only thing is the same the examination. That's how we know this was carried on last occasion.
But other, it will go before the single bench.
No, rule is challenged,
Rule is
but
challenged.
29 is not challenged. It's a separate matter altogether where quantum of economically weaker section percentage reservation, my lord, is challenged. That is not the subject matter in GO 29 or the other matters.
You will detag it.
That has to be
Get it
detached.
separately.
Pleadings are also not complete in it.
Short date may be given because we not
We will give short-
same examination. That's
Right, we give short date, but the issue is separate.
Yes,
Issues is separate but same examination.
Item 71.
Yes, my lord.
Item 71, she attends as senior counsel for the petitioner, she Rajshekar for TPPSC, as the parties fairly submits that in this matter, GO 29, GOMS
29 is not under
challenge.
is not subject matter of challenge, and therefore this may be delinked. They are allowed list this matter separately after 2 weeks.
My name may be reflected, my lord. My name may be reflected, my
Name
lord.
of Shri Rajshekar be reflected in the cause list for TPPSC.
Obliged.
Before you start, learning senior counsel, there is one query. Yesterday, Mr. Sondi argued the matter, and the only point which is pressed before us is that GO 29 is bad in law.
Yes.
And GO 55 should be implemented.
Yes.
In nutshell, this was his argument.
Yes.
Kindly see your relief clause. You have 26038, file
Page
26038. So many things.
His writ petition is item 69, I think so.
26038.
2057. My writ petition is.
No, yesterday he argued from 26038,
Yes, sir.
and that was your case.
Yes, sir.
So kindly see the relief clause.
Well, prayer is page 37.
Yes.
One is, my lord, with regard to the declaring amendment to rule sub 22 sub rule 2, Telangana State sub GOMS number 9.
Are you pressing this relief?
Yes, sir. This I'm pressing.
Because no argument is advanced
No
yesterday.
argument. I'm advancing this argument.
All right.
Yes. This is one. Second is that B, my lord. Declaring GOMS number 29, page 38 bottom.
Yes.
Declaring the GOMS number 29, General Administration Department dated 8 to amending the GOMS number 55 dated 25/4/2022 as illegal, arbitrary, unreasonable, unconstitutional and contrary to so and so judgment, and set aside the same, and in consequential direction directing the respondent to apply a rule of reservation for all categories independently at 1:50 ratio 50 times in the written main examination group 1 service, file notification so and so, issue respondent and issue consequential direction, apply the rule of reservation reserve post by notification calling so and so,
We asked
reserved
you-
in each multi-zone.
We asked you this question because yesterday, although arguments were advanced from this petition,
Yes.
no challenge was made to Rule 22.
Rule 29 we made, no?
No,
B.
Rule 22, Sub-Rule 2.
Is in the petition it is not there, I think so. Not,
The only submission, the question is that yesterday no arguments were advanced.
no
assuming that-
arguments advanced. Yes. Today I will advance arguments in respect of that as my second. First with regard to submissions which 29, 50, 55 is concerned, the small synopsis, Well, your lordships have seen my prayer, Your lordship may take my paper book,
Page 37.
No, page 37, prayer, your lordship have seen, ultimately asking, what he said is the 55 to be followed. in
Yes.
sense. What is the 55, your lordship may just see, for my sake, Your lordship has seen,
Page number.
page 168.
168.
168.
This, how much time this matter is likely to take?
Minute, I will complete within half an hour, 40 minutes.
And anybody else who is appearing for petitioner in this batch of matters?
Yes, Your Lord, Abhishek,
How much time you will take?
Not more than 15 minutes.
There are only two counsel now
yes,
remaining.
yes.
And how much time you will take, Mr. Reddy?
Two councils here, my lord. There is two more councils who are not here. J. Sudhir sir and
Three council, in fact, who are not there.
they expressed yesterday, my lord, that they would need a full day. But yesterday they said,
If they won't come, we will not,
I am not saying that also.
we will not adjourn.
Only- yes.
we will not adjourn the matter. Once hearing commenced with everybody's consent, you are supposed to be here. Yes, yes, after that learned senior counsel, you may advance argument, but we will not adjourn.
they said they'll appear.
Yes, please.
Yes. But you have 55, dated 25/4/2022, page 168. Well, this was issued, Your lordship, yesterday. This was only brought to your lordship notice. There was a notification earlier in the month of April 2022. And this system of calling for selection has been followed. Your lordship will come to relevant clause at page 171. Pattern of examination.
Yes.
There will be preliminary test, objective test, so-and-so general studies test meant for listing, that your lordship can skip that. Come to B. That is a relevant issue for consideration.
Yes.
The number of candidates to be admitted to the written main examination, written main examination. It is admitted case, preliminary examination held, and the mark list is issued in the website.
Kindly read it again. The
Yes.
number of candidates.
Number of candidates, 33,000. I just, your lordship,
No,
I'll
no,
base
this
it-
sentence which you were reading.
I'm reading the 171 P.
Yes.
Number of candidates to be admitted in the written main examination. Conventional type would be 50 times the total number of vacancies available in each multi-zone. Your lordship has seen. Duly following rule of reservation of community. This is important for me. This sentence. The rule of reservation community. This contemplates, after the preliminary examination results, for the main examination, calling for the main examination, they will follow the reservation community wise. Now, my lord, come to the impure GO. Is at page 178.
What is objectionable as per your submission?
This is not objectionable. This amount, this is to be implemented. This is not being implemented. This was implemented earlier 2 occasions for the same post.
GO 55.
Yes.
Yes.
Page 168 will GO 55. 171 is the relevant portion.
Yes.
Now, my lord, this is, my lord, after the, the cancellation of the exam by this honorable court, they issued a fresh notification. In the fresh notification, they amended this before issuing 19.2, page 178, GO 29.
Yes.
Yes. The number of candidates to be admitted. Your lordship, 178 bottom, your lordship.
Yes.
Government, after careful consideration, proposal of Telangana State so and so following amendments to GMS number 55. Then come to the amendment portion. B. The number of candidates to be admitted to the written main examination would be 50 times to the total number of vacancies available in each multi-zone. They said multi-zone wise, number of candidates to be taken. 50 times. Number of candidates to be admitted in the written main examination would be 50 times to the total number of vacancies available in each multi-zone. Thereby, the rule of reservation of community is deleted. Page 171, your lordship, this.
But for the purpose of reservation, there must be some statutory rule governing the field.
Well, it's an admitted case, the rule reservations are there for the backward classes 29%, 15% for the,
For, to govern that, there must be some separate statutory provision.
yes, Rule 22 subordinate service rules are there.
So
There is no
whether or not it is mentioned in the executive instruction, what
this is an
difference?
executive instruction.
That is what we are asking you. If there is a statutory provision which governs how the reservation is to be made, whether or not this is mentioned in the executive instruction, what difference it will make? They are bound by the statutory provision.
Well, this is with regard to procedure of selection. This is not with reference to subordinate service rules following a reservation. They say this is a procedure of selection. As far as the following reservation actually is concerned, they will do in the final. Final selection they will do. They will not do at the stage of the preliminary and main. Now the GO 55, which my lord read as page 171, mandates earlier, at the stage of the, after the preliminary, main stage only, you have to follow the reservation. That was the executive instruction which was followed. Page 171, you will kindly see. What it says, number of candidates, page 171, admitted to the written main examination convention, there would be 50 times. That is not disturbed here. 50 times. Total number of vacancies in each multi-zone. This is same after that. Duly following the reservation for the community. You know, reservation of community, you also know social reservation, which is 29%, 15%, 10%, BCs, SCs, and STs. That reservation would be followed main examination as per the GO 55. Now, Miller, that is dispensed. Saying that, Miller, out of total vacancies, 1 is to 50, without following the reservation. Whether that is legal or not.
But what 22 and 22A says,
Only reservation fix, the pattern of reservation fixation, not with regard to selection. Miller, selection procedure is not contemplated under those rules. That is with regard to the percentage of reservation fixed under those stated subordinate rules. There is no, Miller, dispute on that. The quarrel is that, Miller, from the preliminary examination to main examination, when they are selecting candidates, whether rule of reservation to be followed as per the Indira Sahni principle, Deepen Yadav principle, or Kishore Chowdhury, as your lordship, author of judgment, Miller, that is to be followed. Is the question.
you mean to say that this deletion of this provision of GO 55
Yes.
shows that they do not intend to apply this rule of reservation in preliminary examination level.
Yes, Miller. At the main exam, from preliminary to main. Preliminary to main, they don't want to follow this reservation. That's all the issue, simple issue before your lordship. Whether, Miller, dispensing with the, Miller, following community-wise reservations from preliminary to main examination is legal or not. This is only precise simple issue before your lordship. Miller, this in a 55 is an executive order and 29 is an executive order.
Both are administrative instructions.
Yes.
Yes.
Both are executive order. But, Miller, totally once page GOMS 29 says 50% will be called from total number of vacancies available. Subject to repetition 178, page B. Number of candidates to be admitted in the written main examination would be 50 times. Same as it is 55. Total number of vacancies available each door. This is total number of vacancies has been substituted by rule of reservation. That's all, Miller, the offending portion which is being attacked in this.
Yes.
Miller, I given the synopsis, your lordship, I kindly take up, Miller, that. What are the differences? Just I pointed out.
This is good that you have prepared a comparative chart so that we can.
Yes.
do it. Yes.
Miller, 55.
Yes.
55, Miller, left hand column, highlighted, Miller, number of total vacancies is multi-zone duly following rule of reservation, community of gender, EWH, PH, and sports as laid down in general rules 22. 22A of PS stated subordinate service rules. Then, Miller, 029, right hand column I have here. Miller, in this, your lordship, I kindly see, two things. One is that, the number of candidates admitted written examination, convention type 50 times total number of each vacancy. Total number is one amendment. Second is the proviso is added. This proviso, that in case of any shortfall, because under this, they out of total vacancies, they will call 1 is to 50 for the main without following reservation. GMS number 29, right hand column. if, my lord, if 1:50, if the reserve candidates, SCs, BCs are not coming, what they then they follow the proviso. This is a part of GMS number 29. That provided in case of any shortfall, in respect of reserve category as laid down in rules 22 and 22A, that is percentage of rules to be appointment under the rules, subordinate service rules. Action shall be taken include such a number of vacancy candidates from the merit list beyond 1:50 ratio. This you also this two sentences most important. Beyond 1:50 ratio as required to meet what? Shortfall in the respective categories. Respective categories means your lordship the same note. SC, BCs, SCs.
Yes.
This proviso enables. They call saying that now for the total number of vacancies they go under the merit 1:50 in the substantive provision. In the proviso they say if the meritorious candidates are not coming from the allowed categories SCs, BCs, etc., they will implement the proviso.
Yes.
Now, in fact, in the instant case, they have followed this proviso. They followed this proviso. By which, because there was shortfall in the reserve candidates, they have increased about 3,000 candidates and they called now in the main examination to cover up this. This process is, according to me, is an arbitrary, without any basis. It is violating the rule of reservation.
Yes.
Your Lordship may just permit me to go to the notification once, so that Your Lordship, what are the prejudice, Your Lordship asked yesterday question, what are the prejudices going to be cast? Your Lordship may just permit me to take the notification. 43 it starts.
This is the recent notification, 24 notification.
Oh yes,
Page number.
43 it starts. Come to page 50 .
Yes.
4.1 is which was already read . There will be reservation in direct recruitment in respect of scheduled tribes. 4.1 page 50.
Yes.
4.1. There will be reservations in direct recruitment in respect of STs, scheduled castes, backward classes, economically weaker sections, person with disabilities. That Your Lordship I kindly see. Here that my first pair is concerned person with the disabilities. They have been shown as a vertical reservations. And horizontal reservations in respect of women and meritorious sports persons under Rule 22A, 22A Telangana Subordinate Service Rules.
What is wrong in this?
In this, one thing is that showing, the persons with the disabilities and horizontal in the vertical reservation pattern. They have to be shown horizontal. That is a special reservation. Physically handicapped,
No, there are basically two things. One is social, one is special reservation.
Yes.
So
Disabilities comes under the special.
That's right. So that will be shown as horizontal.
Vertical they are showing. Actually, as per the law laid down by the Supreme Court and Your Lordship, it should be horizontal. But they are showing is in the vertical. Again, I'll read. There will be reservation in the direct recruitment in respect of scheduled tribes, scheduled class, backward classes, economic weaker sections, person with the disabilities and horizontal reservation. Disabilities, that is a vertical. And horizontal reservation will be available only in respect of women and meritorious sports persons under so. That is to that extent is bad, As per the law, I'll take other while arguing that aspect of the matter, I'll take further into the counters, etc.
Yes.
Then coming to the general procedure is concerned. This is a one. Then 4.7 4.9
Yes.
Non-creamy layers certificate from BC form so and so as per GMS number 34 welfare department welfare certificate issued along so and so is acceptable obtained from revenue authority not below the rank of so and so under Telangana. In case of failure provide the same day verification of so and so. There is a non-creamy layer in the backward class, etc. Creamy layer, Your Lordship knows that is.
This notification is under challenge before us.
Well, I'm telling the procedure how it is going to affect
But
me.
is it under challenge before us?
I'm not challenging. I'm saying, my lord, this is the mode of, my lord, the process they have to undergo. Now, by amending that process, what's the merit? Just calling merit 1:50, how it is going to affect, how I am going to cause a prejudice? Well, I'm going to demonstrate it. Because 1 to 50, my lord, total they are calling it. Without taking into this creamy layer and non-creamy layer. Well, a creamy layer person cannot come under the, my lord, category wise, community wise reservation, he can't compete about it. Now, many number of candidates may come from this. For example, in this now particular examination, B category has large number of people have come particular section. Well, this is one. And second is, well, just, page 51. Well, how they have to follow the procedure? Because of the particular Telangana state and with the reference to this notification.
Clause.
The 5.1 is a local reservation also there. Local area, Your Lordship knows presidential order, etc. In fact, the local is the non-local, local separate they have to take. They are as per the presidential order in class 5 and 6. That is also not done. And the local reservation of 90%, 5.1. Local reservation 95% is applicable to all posts notified under multi-zone 1 and multi-zone 2 respectively is applicable as per the para 8 of so and so department.
If you have not challenged London
I'm not-
Senior
I'm not
Council this
challenging.
order,
I'm not
if you have not laid any foundation, they had no opportunity to meet it.
Well, I'm saying, Your Lordship asked me the question yesterday with regard to what prejudice is caused by calling 1:50 on the merit basis. What is happening is that, now this is, for example, 1:50, 28,150 are there. Now, the special reservation is not being followed, vertical, horizontal. The creamy layer party is not followed. The social reservation is not followed, third one. Fourth, this is not followed. And merit, 563 posts into 50, 28,150 will come. Because of, not following this method, which they themselves have prescribed under the notification, especially, social reservation, which is SC, ST, BCs, the other persons, for example, creamy layer persons, non-local, local, non-local persons, and open candidates, large number of open candidates will come under the merit quota. Thereby, reserve persons or community reserve people are unable to come in that 28,150. That is the reason, in this particular examining, particular selection, what they have done is they have applied the proviso and added 300 people from community wise. Your Lordship will get them at that community wise is concerned, page 192, after the this is a list published for the main examination, page 197, 192.
Page number
192.
192.
192.
Yes.
First portion, GO number 29 is extracted, that number of vacancies candidate to be admitted so and so, the proviso. Your Lordship, you have seen that total posts are 563. If Your Lordship take the table, I have given the table next page.
Yes.
This my synopsis, Your Lordship, just see.
The table in your synopsis.
Yes, small synopsis, yes.
Yes.
This in the paper book also, 79 they have given this, page 79. So 67, also Your Lordship will get it, that how the posts have been reserved, but for the convenience purpose, I have given this. This is how the vacancies have been notified. General, 209, 10,450. EWS, 49, 2450. PCA, these are the number of vacancies.
This data you have received from where?
From this one website. This website one.
No, what is the source of this data?
This page 192. Page 192.
182.
192. 192. 192 and page 67. 67 is about the vacancy position, page 67.
On the basis of this page 182, this is,
60, Your Lordship,
this is
Vacancy
worked out
position.
by petitioners.
yes.
This is worked out by you.
Worked out by me, because first is about page 67 is the vacancy position, notified position, page 67.
Yes,
Page 67, Your Lordship, it's a part of the notification.
yes.
Last line, Your Lordship, that is second column of my table.
560,
209, etc. Page 67. Paper.
263, 563.
563. Total 563. Vacancies will not be for category wise, Your Lordship will get it, top, OC, EWS. Page 67 top.
But from where you are getting 209 and all?
Bottom, Your Lord. Bottom. OC bottom, Your Lordship will
Total.
come, Your Lord.
Total, this.
209,
Yes,
49. That is OC, EWS.
yes.
44 is the BCA.
All right,
Total is coming
you
from
were extracted from page 67.
Yes,
Yes,
that is column 3, Your Lord, of my synopsis.
yes.
And the 1:50 ratio which 29 says, column 4. Column 4, 209 into 50, it comes to 10,450.
Yes,
Totally, if this notified vacancy is 1:50 called, they have to call for the main selection 28,150. But they called 31,382.
and this figure you received from?
This figure I got it from page 194. Your Lordship will get of the paper book. Number of candidates, Your Lordship. Page 194 after the columns,
31382.
3 ones. Fifth column bottom I have shown that.
Yes,
Now, fifth column I'll read, All the 563 vacancies are to be treated as open category. Now, as far as the GMS number 29 is concerned, amended procedure I've brought it, Your Lordship. Fifth column, amended procedure as per GMS number 29. Number of candidates to be admitted in examination ratio of 150 each. Instead of up to column 4, it would have been GO 55 procedure. Now, what they have done as per the GO 29 procedure, all the 563 vacancies are treated as open category. All the 563. All these 563. A number of candidates admitted in 563 into times 2850 based on open area. Due to this process, general quota has expanded from 10,450 to 28,150. That's open category, almost entirely is an open category. No horizontal, vertical principle, which is at all stages to be followed. All stages, preliminary, main stages to be followed, has been given go by. This is what happens about the GMS number 28. Due to this process, general quota has been expanded from 10,450 to 28,000. Then 3,238 candidates are admitted beyond 28,000 for mains as required to meet the shortfall in the reserved category. But while counting the shortfall, even the meritorious, this is another sentence which I want Tyler Lordship kindly note. Even the meritorious reserved candidates are included in the reserve quota, thereby restricting reserving slots.
we will request you to kindly read it again.
Yes, Lord. The 3,232 candidates are admitted beyond 28,150 for mains as required to meet the shortfall. As required to meet the shortfall. This is a sentence. In the respective reserved category. Important, Lord. But while counting the shortfall, even the meritorious, this is right, meritorious reserve candidates are included in the reserve quota, thereby restricting reserve slots. Thereby, because the proviso applied, Your Lordship, proviso applied, expanded from 1:50, 28,150 to apply the proviso, they expanded. Why they expanded? Just 1 minute, I'll answer you. Milord, why they expanded? Because special categories that community wise people have not come, they have taken this 3,000. That means, Milord, this follows two, step one. Milord, all the even the merit candidates under the reserve candidates, they restricted up to 1:50 only.
No, we want to understand that what is the material to show. Yesterday, Mr. Aditya also argued on that for shortlisting in preliminary examination, they have not been given the reserve category candidates if they have secured more marks than a general category candidate. He has not been included. What is the material to show that?
Milord, that transparency, Milord, in spite of applying under the Information Act, they are not giving about. With the available material, Milord, I just, Milord, demonstrate. The fact is that, Your Lordship, 29 first substantive portion says total number of vacancies 1:50 to be called. That is 28,150. Why they call 31,382 to comply?
That is one aspect.
Yes.
But your argument that while extending beyond the vacancies prescribed, they are giving benefit to a particular section, or they are treating your merit as within your.
Yes, that's it.
What is the material to show that?
Milord, I don't have, because they are not giving, Milord, any list of this.
On-
I have not, the Information Act applied, they are not giving in it. But, Milord, this proviso.
Please try to understand. What is under challenge before us is GO 29.
Yes,
We are not sitting as an appellate examination body when examination is not even over to see everybody's roll number, who is given which seat, which not. What is under challenge, we will examine only that.
Milord, now, my submission is that, Milord,
This notification is not under challenge before us,
notification 29 is a challenge for Your Lordship.
not this examination notification. You are raising objection about the certain clauses of examination notification
No,
also.
Milord, I am saying that, Milord, the section 20, I am only the part of.
The whole argument yesterday was also that in view of Kishore and in view of the other judgments of Supreme Court,
Yes.
a reserve category candidate, even in preliminary examination, if he secured more marks than a general category candidate, he is entitled to be considered as a general category candidate.
Yes.
Where is the material to show that it is not done in your case?
Milord, the fact that, Milord, 28,150, they have expanded, Milord, 31,382, only to, Milord, follow that proviso, applying the proviso. Proviso, what for applies, Your Lordship, kindly see GMS number, first page, Your Lordship, come here.
You have followed your content.
Yes.
The submission is that if they have exceeded the number, or if they want to fill up the number in the teeth of this proviso by saying that reserve category candidates were not available.
Not available in the 28,150 slots.
Right. So, certain numbers are not available, not the entire.
Not entire. To fill up that,
So if those numbers are not available, what is the material to show that these reserve category candidates secured more marks and they could have secured those numbers?
not marks part of it, Milord. If the 28,150, Milord, Your Lordship, admitted position is that SC/ST categories community wise has not come, therefore they have applied the proviso. By proviso, they expanded 3,000 vacancies, 3,000 extra have been selected. What purpose? To follow reservation, community wise reservation. And they restricted, second limit is restricted, thereby they restricted 1 to 50, even the meritorious person, 1 to 50, because they come to this to select, to follow the reservation. Milord, it deems that the reserve candidate who got the merit, MRC, meritorious candidate, has not been shown in the open 209. Obviously, because
What is the material to show that?
Well,
It's all guesswork.
not, if, I can understand that if they stopped at 28,150.
Milords, may I just interrupt for 1 minute, Milords? Just one thing. Milords, this merit list, to check the merit list would be a factor that would not be available for us because, as Mr. Madan pointed out to your lordships,
If this material is not available, how can we give a finding in absence of material that such an injustice had taken place with you?
that's why, that's
Obvious. Milord, my submission is that this is obvious because of this proviso application. It's obvious, Milord. This 28,150 to 31,382 increased only to follow community reservation, to comply the reservation, 15%, 10% and 29%.
Mr. Madan Mohan, putting it differently, in order to understand the
Yes,
things
yes,
better,
yes.
we'll request you to kindly come to page 178 again,
178, yes.
right? Let us confine to the proviso because
Yes.
this is troubling you.
Yes,
Provided that in case of any shortfall,
in respect of
in
candidates.
respect of candidates in reserve category,
This is
it
what.
means shortfall in the main list.
Yes, yes.
Shortfall in the main list.
Yes, yes.
Right?
Yes.
As laid down in rule 22, 22A of such
Yes,
and such, action shall be taken to include such number of candidates from merit list beyond 150 ratio as required to meet the shortfall in the
Of respective
respective categories. You please explain this
This
second
is what
portion.
I want. This is what I want. The proviso they applied is because shortfall, they expect the shortfall. Shortfall they expected why? Because community wise reservation is not filled up. I have not come on that 28,150 slot. 28,000, 1:50, 563, they have not come.
That is OC candidates.
That's not, total they are.
Total number of vacancies.
OC candidate is 209. Table I have shown is that if OC candidate 209 they have shown, that would have been fine. They are now calling for the merit for entire 563. Here the problem coming up. If subject to your lordship, 209 is only OC seats. Table your lordship will take, general seats are only 209.
Yes.
563 are not general seats. 560 are total reserve candidates inclusive of it. Table your lordship, kindly see, subject to repetition.
Yes.
General is only 209 seats. 563.
Yes.
Your lordship knows this 10,450 should have been called 1:50 ratio. That could have been, as your lordship said it, inclusive of SCs, BCs who are the meritorious candidates. Then, your lordship knows the principle of reservation, how they follow, which is accepted principle by the Honorable Supreme Court and your lordship also. First, the general quota, inclusive of SCs, all reserved candidates. Then comes the community reservation. Or prior to that is that your lordship have taken a different view with regard to carry forward is the next category may come. But otherwise, first is open, then comes BCA, then comes BCB. Like that they have to go. They have to call like that as per the GMS 55. Now in the 29, what they are doing is that all 563, including of this reserve category, reserve notified vacancies, they are calling on en bloc merit from one top merit candidate 1 to 28,150, 1:50 ratio. Thereby reservation is not being followed. By not following, now the fact is that 28,150 reserve communities have not come. They fall back on the proviso. As the lordship rightly said it in the last sentence of the proviso 178.
Yes.
Last sentence is that the lordship has said, from the merit list, they go to 28,150 list beyond 1:50 ratio, as required to meet the shortfall in the respective category. I am saying that now the 3,000 which they have taken instead of 28,150 is from reserve candidates. Thereby, two aspects will follow. One is that it is restricted to 1:50%, 1:50% in respect of their quota only. For example, their quota is concerned, let us take the BCA 44. 44 into 1:2,200 only come. And the merit person has not been shown. That's how they have come to 31,382.
Yes.
That's the one. Well, the second is that, your lordship kindly see. If first general quota 209, 10,450 candidates are supposed to be admitted, 1:50. Your lordship will take the column. As I said, that may come included the SCs and BCs, etc. Now by 563, what's happening? A person from 28,000 open candidate also comes in it. Because 563 they are calling, 563 into 50 they are calling on the basis of the merit. Serial number 1 to 563 into 50. Thereby, the person who could not have come into the total number of vacancies, he would have been open candidate person would have been restricted in 10,450. Even if he gets a 28,150 or a 28,120 or whatever it is, he comes in now for a selection.
Yes.
Why this what happening in that? The persons who cannot come, they are coming into that. 563 total, because total number of vacancies without following the community reservation is being called for the main examination.
But doesn't this show that if there is a shortfall of reserve category in the merit, in the main merit list?
Main merit list.
Those
Right.
reserve category posts, they will fill up by general now,
Yes, my lord.
as per the proviso.
Yes, my lord. Now, my lord, we are restricted only 1 to 50% only of number of vacancies notified in column 3 are being restricted because of this. They are now expanded to fill up, to comply this requirement of.
Yes.
Otherwise, there is no question of, my lord, they are coming to beyond 28,150 had that community was available in that. My lord, they have not given any reason. What is the reason, my lord, why 55 to, my lord, 29 is done? Why this procedure is going to benefit it? My lord, as I said, your lordship, kindly see, my lord, by calling, my lord, for total posts, your lordship notified posts, your lordship see various categories. That comes to total 563. Now, as why I pointed out, my lord, the clause 4.9 and 4.1 and 5 was that, my lord, if the category wise they call, what happens, my lord, the restriction will be there after everybody can compete in the open general. After that, community wise, number of candidates more may come. For example, SC, SC, BCs, suppose 20 people or 30 people come in the open 209. That many slots will be available for them in the community reservation, 1:50. More people will come, SC, STs. That's what the Supreme Court said, Deependra Yadav. And your lordship also said in Kishore Chaudhary. If for a 209, your lordship may take that. Suppose in 209, 10,450, SC, ST, BC, including that creamy layer people cannot seek for the community reservation. Now that distinction is not there. Non-local, local distinction is not there. PSC, vertical, horizontal is not there. En bloc, they are calling all posts, irrespective of the category. Merit. Open candidates may, 563, I may, because they are not giving a data. Open candidates may be more. They will have, open candidates may have a more opportunity to get a final selection. If the reservation is not followed every stage of selection, it will be advantage the persons who are to the general quota candidates and other people. It will be disadvantage to the persons who are entitled for a community wise reservation.
Yes.
The simple answer to this is that we want to merit. This by merit is not being followed. The principle, first my submission, the principle of your lordship reservation, your lordship knows, as held by the Supreme Court and your lordship, is that horizontal, vertical principle to be followed. That is the best method. In fact, Saravaya considered 2 or 3 methods and came to the conclusion that even Indra Sahni said in para 810, 811, 812, I not repeat it because the lordship knows those paras. The best method to follow reservation is that horizontal and vertical. And other accepted principle by the various courts of this country, a settled principle is that first open general
Yes.
will be selected. Then thereafter community wise reservation, including reservation women, PSC, etc. And Article 16(1) contemplates with regard to special reservation. Article 16(4) contemplates with regard to the community wise reservation. The principle of the following of this horizontal article is that so that a proper representation in the public service is represented, because these communities are, reserved communities are economically, socially backwardness. Therefore, the Supreme Court and your lordship followed this method. Now, this method is deviated. By now calling, without following this method, which is being adopted in the Union Public Service Commission, all other service commission except in one or two states, they will not amend 55, which was a procedure which I said that procedure was being followed. They now 29 brought it to help the Lord, calling for the total posts on the merit basis, by which disproportionate number of categories from other categories are coming, but whereas the reserve categories are being restricted to their own percentage. Thereby prejudice is being caused. Had they was called as a notified vacancies as per the category, which is contemplated in 55, which is a policy of law, philosophy of law of the reservations.
Yes.
This anomaly would not have been done. The reserve candidates or the meritorious candidates would have come into the open 209 posts. The balance of people will not, as per the category wise, would have got it more chances, more slots. Now, we not, why is this process, what they are doing, why I am stressing the proviso, the expansion from 28,150 to 31,382 is to comply that 1:15 plus reserve 29%, 15%, 10% respective community reservation ratio. Thereby slots which they would have entitled from these communities who would have got in the open general are being deprived.
Putting it differently,
Yes.
whether this proviso has an impact that number of vacancies, 1:50 ratio, suppose after 1:50 ratio, they have already calculated the vacancies, right? The calculation was
31,000.
563.
Yes.
Right, 563 into 50.
Yes.
Now, as per the proviso, they can go beyond 563 into 50. Is that correct?
No. As per the first limb substantive position, they have to go only 1:15, 563. It comes to 28,050. This is my column 4 million. 563 into 50, it comes to 28,150.
Yes.
But they have gone to
That is what I
31,382.
am precisely asking, that under the, by taking benefit of proviso,
Yes.
they are traveling beyond 50.
Yes, beyond 50.
That is what precisely. we
Yes,
are
that's right, precisely. Traveling behind 50. Beyond 50.
So
But
that
Your Lordship will
amounts
get
to-
it. Page
that-
184. Page 184, Your Lordship will
That
see it.
amounts to filling the post by preparing a zone of consideration,
Yes.
which is beyond 150.
Yes, beyond 1:51. Second is that is being filled up by only reserved communities because they have not come under the merit 28,150. If they call the only open people, general category 209 and a community wise, it would have been restricted to 10,450 only. Notified vacancies, Your Lordship will see chart. General is only 209. They are now expanding general as a 563. General as a 563.
But from where you are getting that they are treating 563 as general?
Well, that is that's what, main section, main 29 itself, B, Your Lordship will see page 178.
Page?
178 main, 178. That's what the 29. B, main substantive provision.
Yes.
The number of candidates to be admitted in the written main examination would be 50 times to the total number of vacancies. 1:50 total number, not community wise, not notified reserve category wise.
No, this is only for the purpose of drawing zone of consideration.
No, for the selecting main examination, from preliminary to main examination.
So you want to say that it should be 263 into 50 for general.
Yes,
Likewise, it should have been compartment wise.
category wise.
This multiplier of 50 should have been applied
Category
category
wise.
wise.
Category wise, that's what 55 says. That is what 55 says.
Sorry, bro.
That is what 55 says.
That is exactly what your Lordship said is right. That's what was the 55, GO
That
55.
was a 55. That's a 55. That is deviated. Your Lordship, kindly see page 171 for my sake.
Yes.
Your Lordship, just see 171 for my sake. This is a 55 substituted.
Page 55.
Yeah, Page 171. Page 055, which now they amended.
Yes.
Earlier to this was that number of candidates to be admitted written main examination would be 50 times, that's the same as it is 29. So the total number of vacancies available each multi-zone duly following the rule of reservation of community. Page 171.
That is clause B.
Clause B. Third sentence. Duly following the rule of reservation of community, that is when Your Lordship just suppose 178, clause B3, Clause B3, 178. 178. B. That rule of reservation and community word is being amended by total number of vacancies. Lordship, you see, this is a reservation by community wise. That third line, B. Total number of vacancies available. Well, even in this also, each multi-zone they have not. Each multi-zone they are supposed to issue each multi-zone separately. Under the presidential order 5 and 6. That also they have not done. They just en bloc merit they have gone in. 563 as an open quota, as a general quota. And that will be applying horizontal way. Because that the principle of reservation is the vertical horizontal would be the ensure participation of all sections in the public service. That is the principle. Now, my lord, 563, nothing but they are going horizontally. They are just going meritorious, all people. If they think that they themselves consider internally what are the categories, what are the shortfall, they will apply the proviso.
You see, when they call 563 must be having the general also, all other categories
yes,
must
you
be
are
part
right.
of 563.
You should right.
The only thing is that you want that it should have been compartmentalized, multiplier of 50 should have been applied category wise. So
Correct.
that the zone of consideration is proper to consider those categories
Yes.
separately,
That's right.
Now, yes, by which
not en bloc.
Not en bloc. By en bloc doing is, I said that, 4.1 of the horizontal is not being followed. 4.9 with regard to the creamy layer is not being followed. Multi-zone is not being followed. Non-local, local cadre, nothing is followed. For example, non-local is entitled for 2% reservation, about 10 vacancies. But meritorious, they may come 30 people. So they are being, large number of sections, who can compete effectively. They are coming in as that meritorious candidate. Whereas, the reserve category, community-wise people are coming less. Thereby they applied proviso. I can only at this point of time, I cannot demonstrate how the category, how the people have been selected, because that is within the wisdom of the Public Service Commission. The fact that they applied the proviso itself is that to follow the community reservation. Because the rule itself says to follow the reserve categories only, that proviso will be applied. And in fact, this is precisely what Your Lordship said, and I'll just take Your Lordship judgment one para, then go to
That spiral. We will start with judgments after the break. The legal submissions are
Yes,
over.
sir.
Now we are coming to the judgments.
Yes.
We will start at 2.
Yes.
Green compilation would be required. No? Judgment part.